All right, I show 10 o'clock. Are you ready, Terry?
I am.
Good. All right. All right. Well, good morning, everyone. I am Patrick Priest. I am the management co-chair of the Management Labor Advisory Committee, and it's my pleasure to welcome you to this February 6th, 2025 meeting. And as we always do, I want to start with an affirmation that management and labor have agreed upon. And I would like to thank everyone for their time, effort, and participation in our work before us today. We want to recognize that it is very difficult and important work, and we appreciate and value the perspectives and professionalism that everyone brings here today. Thank you. And with that, I am going to ask Administrator Terry Watson to please do the roll call.
All right, Sarah Merrick is here in the room with us, and Scott Strickland is here.
Yep, present by video.
Sarah Duckwall.
In here.
Ryan, welcome
Present.
back.
Thank you. I appreciate it. Glad to be here.
Tracy Llewellyn. And Co-Chair Priest, Patrick Priest.
Present.
Kim Schlesinger.
Present.
And Director Stolfi. I'm not certain if he was going to join us or not today. Okay. All right. Okay, so Margaret and Lauren are absent, and we do not have a quorum today.
Okay, all right, well, thank you for that. So we'll not be able to conduct business, but we do have discussion items, and we will proceed with our meeting. The first thing on our meeting after the roll call is public comment. And so is there anyone in the room or online who would like to address this committee? Are there any hands raised in the room, Administrator Watson?
No, there is not, Co-Chair Priest.
And I see nothing online. So with that, I will move forward with reviewing the minutes from the January 23rd, 2025 meeting. They were distributed to us in the caucus. There was one correction that was made. There was a misspelling of Sarah Duckwall's name, as I understand it. And other than that, were there any other comments, questions, concerns on the minutes that anybody wanted to bring up? Well, it's a shame. We all agree, but we can't vote on it. So we'll have to move that forward to our next meeting, and it can be presented with the one correction that was noted. All right, so we'll move on from that to things that don't need votes, and they are department updates. The first of which is the Workers' Compensation Board case law updates, and from Miss Lauren Eldridge.
Thank you, Co-Chair Priest, Co-Chair Strickland, members. Thanks for having me. The board has no update at this time.
Okay. All right, well, that's all right. Could be a quick meeting. We'll see. All right, I'll turn it over to Administrator Watson for WCD updates.
I do just have one quick update. Next week on Monday, February 10th, we will have a new labor member that will be joining us. Her name is, or will be confirmed. I apologize. Emily Rivas will be confirmed on Monday, February 10th in Senate Rules, and she is with the Oregon Nursing Association. So we are excited to have a full MLAC committee. So yay! That's all I have.
Very exciting.
Yeah, excellent news. All right, well, I look forward to welcoming her next meeting, and it's nice to have another nurse on MLAC. You know, that was a nice perspective to have. So, all right, I guess any other updates from the department? None? Okay. All right, well, moving on to our bill presentations. It's my pleasure to turn it over to the Workers' Compensation Division and Matt West, the interim administrator.
Good morning, Co-Chair Priest and Strickland, members of the committee. I'm Matt West, Interim Administrator of the Workers' Compensation Division. Here to talk about first House Bill 2800, which is related to worker leasing companies. I guess want to find out what the how you all would like to proceed. I know we don't have a quorum, so there's not going to be any action on the bill, but I'm happy to give a brief overview, give a detailed overview, table it, kind of whatever the committee would like for today.
I think administrator or interim administrator, that it would be nice to be able to solicit any questions. I know we do have, people that are here that it would expedite votes later if they could have their questions asked. I don't know. Are there any questions from the
If you'd like, I can give a brief, like, kind of high level overview, and then open it up to questions if that works.
Sure, yeah. No, please do.
Great. So, great. So I'm here to talk about House Bill 2800 with the -1 amendment, which updates current worker leasing statutes. Just for your information, there was a public hearing this past Monday at the House Labor and Workplace Standards Committee. The committee chair and members eagerly, my words, eagerly, await MLAC's input on the bill before scheduling a work session. I did present this as this to MLAC on December 5th when it was still a legislative concept. So just a kind of high level, several provisions of ORS 656850, which is Oregon's worker leasing law, don't reflect changes to industry practice or improvements in technology since the law was enacted in 1993. So we're requesting to make statutory changes that will address several of these outdated provisions, terminology, and definitions to reflect more current model practices for professional employer organizations or PEOs. The changes will also help update current paper-based reporting processes and allow insurers to report coverage changes electronically via electronic data interchange on behalf of the worker leasing company and their clients to the division. Additionally, the updates in the coverage provisions will close existing gaps and allow the use of multiple coordinated policies, which is something that we would later discuss during the rulemaking process as to whether or not that would be implemented a requirement or suggestion. We would want the industry's input on that. Making these changes to the statute would decrease the likelihood of coverage and licensing disputes and also significantly reduce administrative burdens on worker leasing companies and the division. And then just to kind of cover the -1 amendments. So these amendments make minor technical changes to the bill, some of which we discussed back in December at the December 5th meeting, and these are based on input from a number of stakeholders. So the -1 expands the definition of co-employee and PEO to clarify that a PEO assumes employment responsibilities as allocated under its contract with a specific client. Also restores the requirement that a PEO notify the division as well as its insurer and client when terminating a coverage obligation. And this was in direct response to stakeholder concerns about removing the division from the coverage termination process altogether. Also provides a method for PEOs to give notice of terminations to clients who are LLCs. The original law back in 1993 took effect before Oregon law allowed for LLCs, so there was this gap. So we're adding that. And then based on feedback, moving the operative date of the bill, if passed, from January 1st of 2027 to July 1st of 2027 to give stakeholders time to update their systems and work out new processes. So that's what the -1 amendment does. Happy to answer any questions related to the bill, the -1 amendments, or anything worker leasing related.
I see one question from Sarah Duckwall.
Thank you, Co-Chair Priest. And Matt, my question is, what companies do you imagine or envision remaining under the worker leasing category versus moving everyone essentially over to PEO?
Thank you for the question. So with this bill, we would remove the worker leasing name and definition from statute and replace it with professional employer organization. And we believe that the vast majority, if not all, of current worker leasing companies would fit the definition, would continue to be considered professional employer organizations under the new definition.
Okay, thank you. When I was reading the analysis, it made reference to retaining worker leasing companies. So I just wanted to see, I was trying to envision what would remain, but that's clear that it will be removed. Thank you. And I do appreciate the streamlining and the efficiency update. I think anywhere we can do that is helpful in all aspects of every organization. So thank you for that fix.
Thank you.
Thank you for that question, Sarah. Are there any other questions? Scott Strickland has a question.
Yes, thank you, Co-Chair Priest. I guess I go back to the question. I know I raised the issue last time of the co-employment language having a possibility of confusing workers and employees and potentially some advocacy organizations that represent those folks. I know that we heard feedback last time that this is based on a model statute, and so there was no interest in kind of changing that phrasing. That doesn't strike me as following the Oregon way, however we ascribe whatever meaning we ascribe to that. I guess I still am having a little difficulty here in understanding. So we're not necessarily talking about temp agencies, right? Which is kind of what I would have considered worker leasing companies previously. We're talking about service providers that provide a lot of these services, but that don't sort of directly control workers in the way that a temp agency does, or are we still talking exclusively about sort of the temp agency model?
Yeah, that's a great question. So temp agencies or temporary service provider is defined in this statute as well, to kind of make the distinction between what is a worker leasing company or a professional employer organization versus what is a temporary service provider. And I guess the way maybe a simple way to kind of see the differences, the worker leasing company or PEO has a contract with the client employer, where a temporary service provider or temp agency has a contract with an individual worker and is placing that worker with different clients. So it's a different model, and like the definition helps clarify that. So yes, it's related in that it's in the statute, but the majority of the changes are related to the worker leasing companies and professional employer organizations. Does that help clarify that piece of the question?
Yes, thank you. I think I understand that better now.
And then as far as the co-employment, we provided some information to MLAC in response to that. Just looking for it, but I don't see it. But also wanted to flag, the relating to clause for this bill is specific to workers' compensation. So we're not creating a co-employment relationship for purposes other than workers' compensation. That helps.
Thank you. Yes. And I think my concern's not as much that there would be necessarily a legal effect, at least anytime soon, because it seems clear that there's the intent to limit that relationship only for the purposes of workers' comp. It's more a concern that folks that are trying to navigate the already complicated system themselves may be deterred. Unsophisticated folks that don't have law degrees, that don't have access to legislative history, may be deterred from otherwise filing claims because of a misunderstanding that the co-employment relationship is more expansive than work comp only. So it's not so much that there would be an actual legal effect, but that workers may interpret that incorrectly as applying to other circumstances and scenarios. I think that's I don't know if that makes sense, but I don't want to say muddying the waters for lay people, but to some extent, that's kind of the concern that I have. Happy to reach out more on that. I know that we had the individual, I think, who was in charge of the organization that kind of put together the model rules present previously, and that was the answer. And maybe I can reach out to some folks and get some input in where this has been rolled out elsewhere. Has there been any sort of unintended consequence of workers and others misunderstanding the application or the breadth of the application of this change?
Okay.
So
Yeah,
that's an on me thing. I can help reach out and get in touch with some folks on that. So
and that's fair, and we're happy to facilitate that. Also, for what it's worth, you know, in practice, in the real world, and maybe this is something that you know, those that work in the PEO industry can talk about. Nothing is really changing in how current practice is. It's terminology and statute and how we define them to make it clearer. So there wouldn't changing this in the statute. I would say a worker wouldn't necessarily know in practice that anything has changed, that they're if they work for a client employer, that the client employer's relationship with the PEO is now considered a PEO instead of a worker leasing company, or how it's defined. In practice, they probably wouldn't even know that anything happened. If that makes sense.
yes, no, and I think that, again, I'm more concerned about ignorant AI Google searching that then leads to misunderstandings and amalgamations of what the law actually is. I think in that case, and that being kind of a heightened and accelerating problem as more people eschew traditional institutions of, you know, going to someone who is an attorney or going to you know, their union rep or something, and instead just seeing what they can find on their cell phone. So again, I don't know that there's a problem there, and I don't know that the problem could not just be fixed by ensuring that on the form it says, you know, on the form or in the rulemaking it clarifies as well that this is co-employment for this purpose only and in this scope only. That may address the concern. I still am not completely comfortable with the potential for confusion there in the joys of the modern age that we face.
Great, thank you. You mean like if somebody goes to the doctor and then uses WebMD to try to diagnose themselves? Is that
Exactly. Or when you ask your friend when they have self-diagnosed something and you say, oh, well, did you go talk to the doctor about that? And they say, no, I took a form quiz that I found on social media.
All right, I see Sarah's got a follow-up question as well.
Yeah, I just want to address Scott, if I may. Scott, can you help me understand? You're worried about the concern of someone not wanting to file a workers' comp claim due to the co-employment? Is that right? Or am I missing that?
So it's twofold. One would be a misunderstanding of how broad the exclusive remedy is in this case. I know that we heard that the exclusive remedy is not broadened, but if there's the co-employment language, so the case that, or the example that I brought forth of an individual on a construction site who is a worker that is going through a PEO to work for contractor A. And the PEO also represents contractors B and C who are on site and who are being negligent. So traditionally, the worker would have negligence claims potentially. Again, you know, it depends in law, but potentially against negligent contractors B and C. But if the worker is trying to investigate this and understand the situation, or the, you know, nonprofit that has a paralegal that's looking into this or something, someone who's maybe not as legally sophisticated, although most paralegals would be competent and proficient in that sense, there's a possibility of a misunderstanding that the co-employment applies to the worker, the PEO, and that the other B and C contractors may be covered as well because they're all utilizing that PEO, and then they are the exclusive remedy would apply and they're not able to go after them. So that's kind of one set of concerns that I have about the possibility for confusion. The other set has to do with applying the concept of co-employment to other issues like labor law, and whether they would have the way in which Section 7 rights would apply and other things like that based on joint employer status. And whether your average worker can understand that co-employment for workers' comp only does not in any way affect joint employer status and the impacts throughout the employment relationship for that. So I think there's kind of twofold concern that I have about that. I may be off base and kind of running out too far into the fringe in that sense, but those are the two concerns that I have. I would just like to reach out to some stakeholders where these laws have been rolled out to ensure that these are not problems that actually pop up. I don't
Thank
know
you
if
for
that
the
answers the
clarification.
question.
It
Yeah.
does, thank you.
Thanks.
Thank you, Scott. That helped me understand better your concern. Is there anything, since we're not going to vote on it today, is there anything, like you said, looking at other states that perhaps have laws related to PEOs? Is that something you'd like the department to work on and before we vote on it?
If I could, I'll do some outreach to some stakeholders there in some other states, but if I could get a list of where else at least similar, if not the same model language has rolled out, if we haven't received that already, that would be helpful.
Okay.
Thank you for that. I don't know if there are any stakeholders on the line that maybe are very familiar with this. We have talked to experts from that industry. I don't know, since we're running short today, I'd call on one of them if they're on the line to unmute or raise their hand.
Have someone in the room, co-chair.
Great.
Hi, Jenny Dressler here for the National Association of Professional Employer Organizations. Our understanding is that, to answer your first question, our understanding is that this does not change or extend the scope of workers' compensation coverage or anything around that. It's just a definitional change, or it's a definitional terminology change for our industry. Everything else is supposed to stay the same with the exception of streamlining. And I'm happy to answer your questions around co-employment versus joint employment, but you'll see in the -1 amendment that it specifically calls out what temporary service providers are, and that is more your joint employment situation. And so that one's called out as not being part of the co-employment. Co-employment is just generally one of the ways that small and mid-sized employers are able to access much better workplace benefits for their employees, among other services, regulatory compliance, assistance and support, tax compliance support. But as co-employers, the PEOs are able to access like healthcare plans, 401k plans, and provide those to small employers who may not have access to those kind of plans of that size because their workforces are smaller. And so that's the model of co-employment. We are absolutely happy to follow up with you with and talk through which states have adopted this exact model language or something very similar. But PEOs do operate in all 50 states. The terminology is a little bit different because as in 1993, when the industry was regulated or became regulated in Oregon under the license and workers' compensation laws. At that time, worker leasing company was the terminology used. In 2025, the terminology used is professional employer organization. The model hasn't changed for what the business is, but the language has, the verbiage has. And so that is what this bill essentially is, but really happy to do a deeper dive with you on and answer some of those questions. that you raised today about the differences between co-employment and joint employment, and the services that are provided.
Thank you. I think that would be very helpful, and I very much appreciate that. I guess a follow-up question to that. So I think I'm familiar with what you're talking about with the sort of access to healthcare plans and other things like that as a block instead of, just a one-off individual employer trying to negotiate by themselves. So does that impact the experience rating? Are they able to use the work comp experience rating of the PEO?
I'm going to defer over to the workers' comp division.
Yes,
for that.
I can answer that question. So when an injury occurs, the injury is reported and tracked at the client level. So the experience rating stays with that client. So if that client employer were to leave and either secure their own workers' comp insurance policy outside of a PEO contract or move to a different PEO, their experience rating follows them. And this doesn't change. That's current practice, and this does not change that.
Gotcha. But if they're sort of, the PEO may be the insured party, right? So the PEO's experience rating would be what is used to actually purchase the policy, or am I misunderstanding that?
So I don't write policy. My understanding, so the insurer may give, because you have the PEO and a number of clients, they may negotiate a better rate for the policy. That's between the insurer and the PEO on what they're charging and their clients. But when it gets down to the practice of the experience rating of an individual client employer and how that, that stays with that employer. So I'm going to stay in my lane and pause there.
I see a
I think we
hand
have somebody from
raised.
Sure who has their hand up, so they might be able to help clarify.
Yes.
Hi, this is Faith at Sedgwick. What we see from underwriting often in PEO and other similar structures for coverage is that the group gets their coverage by group, the people in those groups. So if it's a worker leasing group or other PEO type group, the person in charge of that group basically does their own valuation while bringing those partners into the group for rating. So as you said, the NCCI experience modification for the individual employers is their own and it goes with them. But as they're looking at these other groups for coverage, the group overall purchases and picks and chooses and evaluates what portion of the overall policy is paid for based on that individual employer's experience. Does that make sense?
Nobody has a follow-up question. I don't know.
So the answer is yes and no and maybe, kind of.
It
Yes,
depends
no,
on which
maybe.
level you're looking at. Yeah.
No, I think that's helpful in understanding that, and I'll follow up with additional concerns. As I said, the main concern that I had was about the possibility of confusion there. So happy to follow up with that, and thank you very much to everyone for the additional information, and to Interim Administrator West for for being patient with me and slogging through this. I appreciate that.
Yeah, thank you very. Thanks for the question, Scott. I think it's a good one to explore, and I want to thank the two stakeholders for speaking up and in providing that valuable insight, as well as our interim administrator. And with that, is there anything else on that particular bill that we want to discuss, or should we move on to the next one? Yeah, I think we should go ahead and move on to the next one. And I think a summary if you don't mind, and the explanation of the amendment would be in order.
Great. Thank you. So, so the next bill on the agenda to be discussed is House Bill 2802, which you may recall is a bill to update the existing statute for when a worker is able to receive a lump sum payment of their permanent partial disability award. So prior to 2023, when a worker waived the right to appeal the adequacy of their permanent partial disability award, they were able to get their award in one lump sum payment. The Court of Appeals decision in 2023 changed that, and so current state would be the worker would have to wait up to 60 days for their appeal rights to fully expire and for the award to be final by operation of law before they could get a lump sum payment. So the main purpose of this bill is to add language to clarify that if a worker waives their right to request, it's a lot of R's, waives their right to request reconsideration of the notice of closure. And reconsideration, for those that may not be aware, that's the name of the appeal process for notice of closure. So essentially they're waiving their right to appeal the notice of closure. Then they would be able to get their permanent partial disability award in a lump sum as opposed to monthly payments. And I had mentioned this at the public hearing. A month, depending on the size of the award, the monthly payments could take several years to pay the entire award out. So for what it's worth. We did present the bill at the House Labor and Workplace Standards Committee on Monday as well. One of the other parts of the -1 amendment wasn't part of our original concept, but after meeting with stakeholders, there was the appetite to look at the $6,000 automatic payment of permanent partial disability. So the way that the law is currently written is if the worker's disability award is less than $6,000, so $5,999.99 or less, they would get that in one check automatically. It's been that amount since 1995, and so that while we were changing the other piece, there was the request to have the discussion on should that be raised. So the -1 amendment does raise that to $9,000 for automatic, or anything less than $9,000 for an automatic payment of the permanent partial disability award. That was flagged at the hearing on Monday as well. Let me back up. So general support for the bill and what we're trying to accomplish. Two issues were raised at the public hearing related to the bill. So one, just that automatic lump sum threshold, whether or not it should move up to $9,000 or not. I believe Safe Corporation flagged that and may be prepared to talk a little bit about that. And then the other issue was flagged related to, in the current statute, so it's nothing that we're changing, but in the current statute, it says that a worker is not eligible to receive a lump sum payment if they are enrolled and actively engaged in training. There's another bill, House Bill 2791, that's looking to change payments of VOC. And sort of, if that bill passes, there would be a conflict with that part of the statute, even though it's not part of our bill. So that was also flagged at the hearing by OTLA. And so Chair Graber asked that we deconflict the two issues through the MLAC process. So that's part of the reason we wanted to have the discussion today. Happy to expand on any part of that and answer any questions. I did give both OTLA and SAFE a heads up, since they were the ones that raised issue at the hearing, a heads up that we were going to be having the discussion today, so that nobody was blindsided by what I was going to say. So
Wonderful. Well, maybe I'll pause to see if there are questions, and if not, we'll move on to the stakeholders, I don't know, testimony. Sounds like that's anticipated. You want to hear from them first or ask questions of we'll hear from them first. All right. I don't know, whoever is ready. I don't want to play favorites. and whoever can get up there first, yes.
Mr. Co-Chair,
Yeah.
Ivo Trummer here. I'm happy to go first, unless
Great,
Keith
thank
wants
you.
to beat me to it, or Giovanna. So, co-chairs, members of MLAC, for the record, Ivo Trummer, Government Relations Director for SAFE. First, I want to just say thank Matt West and Terry and the team at WCD. They have conducted really robust outreach to all the stakeholders, not just us, but every stakeholder on the issue. And that's really, it's refreshing, and it makes it so easier to kind of work through the details here. So I want to just express our appreciation for their work on this one. I want to make clear that we fully support the bill as introduced, 2802 as introduced. Absolutely, that issue should get fixed. We're glad that the department took the leadership to kind of address this. The -1 is problematic, and I will flag that the 6,000 automatic payout threshold has been in statute, I think, since 95, and it's true that has been 30 years, and we would have interest to kind of address that and look at, is that the right number? What has changed in the 30 years is House Bill 4138 in 2022 that makes it that now when we do a PPD award and that gets appealed, a PPD award under $6,000, and that gets appealed, the PPD award is now considered an overpayment. And let's say it was a formality and we reissue the PPD award, or it gets reissued at $6,000. Used to be, we look at those two and say, well, we already paid it, we're good. Or we paid a difference, whatever it might be. Now it's considered an overpayment, so we are due to pay out $6,000 again. And we look at the overpayment and reduce sort of the new payment, the same $6,000, if you will, by half, $3,000, and pay out $3,000. So in the end, we have paid out $9,000, or 1.5 times the original PPD award to the worker, which, you know, understandable, it's more money. On the other hand, the problem that gets created for the worker is the other half we will recover from a potential future benefit, either from the same claim or from a potential future claim. That is the current situation that House Bill 4138 created. It is what it is. Our concern is if we raise that threshold, and by all means, let's raise it. But if we raise it and not fix that issue, that problem just snowballs into a bigger problem for both worker and insurer. And so absent that fix, we cannot support the dashboard.
I guess we'll hear from Otla and then ask our questions. Thank you, Ivo. That was well explained. Thank you.
Thank you.
I have Keith Simple with his hand raised.
Yes, thank you. Keith Simple, Oregon Trial Lawyers Association. We do support raising the automatic lump sum payment from $6,000 to $9,000. It's a very small increase. We do understand the concerns expressed by SAFE, but we would still like to see this adjusted ever so slightly to account for the fact that it hasn't been adjusted for so long. We don't think that this change is going to really affect things with regard to recovery of overpayments, but we do understand the concern. We just think that this is a needed change and a reasonable one. Thank you.
Thank you for explaining that, Mr. Simple. And I'll start out with one question. You know, it was interim administrator West. You started out by saying that having MLAC look at, you know, correcting things or options. Are there any options before us to correct? Like if we wanted to address the -1 amendment and make it agreeable to all, what are the options to do so?
Co-Chair Priest, that's great. I was actually just jotting down options, so great question. It's like you were in my head. So, you know, I sort of see it as 3 options, and if others see as other options, then that's fine. Would be happy to hear it. So one option is, you know, leave it at 9, or leave it as the -1 at 9,000 as is. Support that. The other option is it could go back to 6,000 as the original amount, and we can see if there's support for that. And the other option would be leave it at 9,000 and look to address the overpayment issue, or even increase it more if the overpayment issue is corrected. So I see kind of 3 potential paths. Again, this wasn't originally part of our purpose in bringing the bill forward, is to correct that overpayment issue of lump sum. So we don't necessarily have a preferred option. We're just happy to have the discussion, and hopefully we can come to something that's agreeable to get the bill passed. And if others think of other options, those are just the three that popped into my head right away.
Is there, how would you fix the overpayment option, I guess it sounds nice to fix it, but I'm not sure. How in practice would that happen?
I believe it would require some language change in 6.5, is it 2.6? I don't want, I saw Evo come off the camera. He probably knows the statute site. It would require a change to a different statute.
And thank you, Matt, for the confidence, but no, I don't know the statute said. We had drafted some language, it's 656.268. Thank you, Elaine.
16.
Did you get that? I can get it.
Yeah, it's 656, 268 sub 16 sub A.
We had drafted some language that we shared with some of the stakeholders here on the call, but I think no consensus was reached thus far.
Okay. All right, well, thank you. Something that's not before the committee would be the fix, and it'd be something that'd have to come later. If there was such a thing, that's what I'm hearing. Are there any other questions from the caucus members or clarifications? I see Sarah Merrick with her hand raised, so.
I hope that I haven't missed this data. Do we have data on how often the overpayment occurs, on how that, and how often the employees or affected individual needs to pay that back through a claim later on?
So we don't at the division. That's not something that we track. I don't know if insurers have data on how often that occurs.
It's just hard to understand the impact without some numbers.
Good point. Thanks, Sarah. Thank you.
I would have to see if somebody's on the call who can answer that, but so give me a moment.
All right, Sarah Duckwall had her hand raised as well, I think. Yeah.
Yeah, this is, I asked 2 points. First, I'm not sure the insurer should take on a greater number. That doesn't seem quite fair and equitable. So I'm challenged by understanding the reason why it shouldn't be addressed if we're increasing the dollar figure. And then second, this is a conflict with the additional bill out there. Terry, you mentioned the number, but how would that, put those back in agreement without addressing them together? The vocational training piece.
Sure. Yeah, and I think, as I mentioned, that's something that exists in current statute that our bill is not changing or tweaking. One idea would be to for House Bill 2791 could have an amendment that, if passed, it would delete that portion out of 65623 out of the lump sum statute. So if that were passed, because that bill addresses permanent partial disability payments during vocational training and would allow for a lump sum. So one option, a potential amendment could be that it would then delete the provision in 65623 related to being in training as the disqualifier for a lump sum.
Okay, so there is a path forward without making them disparate.
I would think so.
Okay, thank you.
Any other comments, questions? Evo, I see you went up.
Yeah, Mr. Chair, I heard from the smart people at SAFE and the team. It would take us a little while to dig into the numbers, so we'll get back to you on how often this happens.
Okay. I see a hand raised from John Probst. I'll go ahead and get his expertise.
Good afternoon, members of the committee. My name is John Probst. I'm a claims manager here at Sedgwick in Portland. We are fully supportive of the bill, and the concerns raised by SAFE are acknowledged as being important. However, it should be noted that, at least in our experience, it hardly ever happens where the overpayment would have to be a serious consideration.
I'm hearing you say that to Sarah Merrick's question about how often it occurs. In your experience, it has not been very often.
It's hardly ever.
Thank you. And I'm not as familiar with like the scope of Sedgwick's, like claims handling. Like how many claims do you handle? Like what portion of the work comp businesses Sedgwick represent?
We are the second largest processor of workers' compensation claims in the state behind SAFE.
Okay, well, there you go. Thank you for going off mute and offering that valuable information. All right, your hand is still raised. Did you have another question or comment or? Yeah. Any other questions or issues? All right. Is there any feedback that the committee we can't vote, but we can ask for follow-up? There's one bit of information that Sarah Merrick asked for, and I know SAFE was going to work on it, and we got an answer from one gentleman from the second largest processor, but we have that come back. I think I heard a potential solution in another bill that could possibly come back with this when it comes back to us. Is there anything else that we as a committee or interim administrator, did you have a question?
I just wanted to clarify. There were two sort of issues. The other bill fix potential isn't related to this lump, like the automatic payment. It's related to the other concern that was raised, which is the vocational training disqualifier for a lump sum. So that would not address anything related to raising the automatic threshold or not.
Okay. All right. So perhaps the better thing to bring back is there a solution to the concern that was raised about the automatic payment or about the overpayments that SAFE's concerned? Like what would be a solution that could address that, if there is one? That's another thing that we could bring back next time.
Co-Chair Priest, I heard there was
Sure.
language proposed. May we ask for them to work on that?
So is that you heard that from SAFE, from Evo? Was that one of
That the language was proposed, but yeah, I mean, I think that we should ask for them to consider a solution.
Right. Evo, I saw you went off camera again. It's always
We'd be happy.
something good's gonna happen when you go off camera. So
We'd be happy. We'll probably would ask them for an amendment to kind of address that issue and then bring the amendment to the next conversation. We'll go through the committee if that's agreeable.
yes, that would be, to me at least, I don't know.
Yeah.
Be part of the next time this bill is brought forward. That would be nice to have as part of that conversation. Is there anything else? All right. Well, I think have we talked through all of it? Are we ready to move on to the next item on our agenda? Matt, I see you've closed your book, so I think we're ready to go. We're ready to move on. So.
I can reopen it if there are further questions.
I don't have anything else. So thank you very much for all of that and for all your work. All right. Are there any other bills that perhaps are not on the agenda that we want to add? Administrator Watson, is there anything else? Any other business?
We just need to talk about the next meeting. My understanding is we will not have a quorum on the 13th. So should we push the meeting to the 20th? Cancel the 13th and meet on the 20th? My question to you.
So I think I will ask the committee members, at least the ones on the call, just to confirm you're not available on the 13th and that you would be available on the 20th. I'm available both days, so I am available on the 20th as well. How about, is everyone here available on the 20th at our scheduled time?
I'm actually not available on the 20th either, looking at my calendar. So, but that might not prevent a quorum, but I will not be available till the 27th unless we change the day.
Yeah, and I have a firm conflict until 11 o'clock that day, so I won't be at the normal time either.
On the 20th, so that's 2 or 5, we need 3. I'm available. Kim and Ryan, are you available?
I'm available on the 20th. I do have a conflict on the 13th.
Okay.
I'm available on both days.
Okay, so we would
Kim,
have 3 is
I'm
3 is
available
a
both days.
quorum, right? Isn't that right, Terry? 3 on each caucus?
3 on each caucus,
Okay,
yes.
and then so for the labor side, I'll let, so we have 2 that are here. Are you both available on the 20th?
I'm available both days.
Sarah said she was, Scott said he was on the 20th. Margaret will be back on the 20th. And then we'll have Emily, our new member, and I don't know about Lauren. Co-chair, I see that Giovanna Patrick has her hand up. Did you see
Sure,
that?
yeah. We'll go ahead and we'll let her do that. Giovanna, go ahead and ask your question. You.
Yes, thank you. Sorry to interrupt. Giovanna Patrick from OTLA here. I just have some concerns about pushing our MLAC meetings out because I know the legislators really want MLAC to vote on things before they will consider some of our matters or move them forward. And I just have some serious concerns that if we move this to the 20th or later, that some of these things that we've all been working on will not move forward in the legislature because we won't have the chance to present them to MLAC for a vote.
Yeah.
I don't know what the solution is, but I just wanted to raise that issue. Thank you.
Well, that's an important issue, and I know you work really hard on these bills, so I'm available the 13th and the 20th. I don't know can we pick different days, Administrator Watson? Like if we asked for I don't know, a doodle poll and picked times that are not on Thursdays, is that an option for us, or do we have to stick to a normal schedule and these announced dates and times?
Well, right now we're only talking about the 13th. If we can meet on the 20th, it's only canceling 1 meeting. And if we can get these bills that we had today on the 20th, and then we have ASME's bill on the 20th as well, I think we would be caught back up. We're only talking about the meeting on the 13th. So, and we will have Emily, our new member as well from labor. So,
okay. All right, I see Scott Strickland with his hand raised as well.
Yeah, I would maybe suggest that we keep the meeting at least for now. I know that occasionally things get canceled or I'm able to make a meeting when I don't think that I would otherwise, so that there'd be a possibility and we could at least get an update and kind of hold space for the stakeholders to engage on these issues as well. So I would say if we could hold the meeting time, at least for now, that would maybe be helpful. If we don't have a quorum, at least there can be a brief update and then time for the stakeholders to really get to the nitty-gritty on these issues. But I'm fine either way. I'm available both days, so whatever works for everyone else.
Today's
Consider
meeting
a meeting shift as well. Earlier in the week of the 20th, the 18th or 19th. It is a long session, so we do have extra time before deadlines occur. So I'm not sure we need to quite rush yet.
I think we have till April, so I think there's still plenty of time in session.
And I heard we threw a lot of ideas at you, Terry. What did we settle on keeping? We're gonna keep the meeting on the 20th. I heard for sure. And perhaps there was an option to just keep the meeting on the 13th and decide later, maybe hold the meeting just to have discussion without votes. Or maybe someone that's not available now would become available. Although at least in my own caucus, I heard some certainty that people were not available on the 13th. So I don't know that will happen.
Well, and Co-Chair, the other thing that we're dealing with is not getting amendments in time. So if we don't, and that was Odalia's issue today. We couldn't get the amendment before I had to post the agenda. I have to post the agenda in time to get out on Gov Delivery. So there's these different things that we're dealing with. Has to be public notice and in a reasonable anyway. So yeah.
Do we want to say hold the meeting on the 13th for now? Definitely keep the meeting on the 20th. Patrick and I can verify with our caucuses and get back to you by end of business day today, and then notice can be sent out from there if that works for folks.
That's fair. Thank you.
That's fair to me too. Sarah Duckwall had one open question, which was, do we want to seek a date earlier in the week of the 20th, maybe the 18th or 19th, and just do some sort of query of caucus members to see if there's a time where there's a quorum earlier in the week? Did I get that right, Sarah? Is that's what you would like? Okay. Is that something agreeable to you, Scott, or Terry?
Yeah, I know the 18th won't work for me, but the 19th might. So let me get with my caucus, and then I think we can get back to Terry by end of day today.
That sounds good.
All right. And then just remember, I need to send the agenda out 2 days ahead of time, so, and get it on Gov Delivery, so, yeah.
Well, I mean, I don't know, would we want a meeting on the 19th and the 20th? So I have two meetings it'd be instead of the one on the 20th. And you're not available on the 20th, right, Sarah? That was the reason why? Yeah.
That's correct. I have a full day of meetings that day, so I apologize. You don't have to change for me. I just like to be here if I can.
Yeah, I appreciate that. So. All right, well, there we go. Not 100% clear, but we are we've got the 20th. We're 100% clear. We're keeping the meeting on the 20th. So, all right, well, with that, is there any other business to be brought before our committee today? Since we're ending early, I will ask for a motion to adjourn. Oh, wait, I can't. There's no actions. We can't take action. So I guess I'll just let people have comment. Is there anybody on the committee or among on the committee, on the caucuses that has any other business they'd like to bring forward? All right, well, hearing none, I will adjourn the meeting. Thank you very much for your time and attention today.
Thank you, everyone.
Thank you.
Thank you.